Hello, this is the Herschensohn podcast. I am the host of the Herschensohn podcast, Zach Herschensohn. I'm the owner of Herschensohn Law, a law firm that is focused exclusively on providing excellent legal services for people injured by the negligence of others. We currently have three offices: Kent, Washington, Graham, Washington, and Ellensburg, Washington. I've been practicing personal injury law continuously since 2003, and I've been the owner of Herschensohn Law since 2009. We are currently accepting clients who've been injured in motor vehicle collisions, falls due to environmental hazards, trip and fall, slip and fall, Jones Act, and other workplace injuries, as well as all manner of other injuries where someone is injured through the negligence of others. On this podcast, we focus on topics of interest to lawyers who do personal injury. We also create content of interest to personal injury lawyers that may be helpful to their clients. Today, we're here to discuss a recent successful jury verdict we obtained on behalf of one of our clients, Aaron Wood. On May 3rd, 2024, a Seattle jury awarded $2,700,000 to Ms. Wood for her permanent back injury. The basis for the award was 100% general damages due to a back injury she sustained on October 30th, 2020. This was a very challenging case. And we have two individuals here who were involved in that case: lead counsel Joe Pivenich, and second chair Rob Fulton. Thank you so much for joining us, gentlemen.
Thanks for having us.
Thank you.
This is the third podcast that I've done, and the first time I've had guests on this show. And so I am a little new at this, but what I'd like to do is I'd like to give you the opportunity to introduce yourself to the audience, starting with Joe. Joe, can you first start out by telling us a little bit about your current law practice and a bit about how you got into that?
Sure. So I've been a lawyer for about 15 years or so. And my current law practice is focused mainly around trials. So we don't take every case we have to trial, but we take a lot of them to trial. And the majority of the things that come in the office tend to be things that could make it to trial, and that's our main focus, is to really improve at the art and the science of going to trial and representing just people, regular people. So it's mostly all injuries, catastrophic injuries for the most part. And we tend to represent just regular people. Actually, it's all we represent. We don't represent the government. We don't represent big corporations. Certainly don't work for any insurance companies. And everything we do is about, valuing people versus what insurance companies like to do, which is typically only value things they can quantify as opposed to the human experience and things that are important. So that's what we do. And that's kind of the gist of it.
Now, I know you currently only represent plaintiffs, you personally and your law firm, but I know that was not always the case. Can you tell us a little bit about your professional journey, how you wound up in a position where you are representing only plaintiffs, and how that changed over time?
Yeah. See if I can do the really short version, which is got to law school during the recession in 2010. I went to school at Tulane. I studied maritime law, and I picked maritime law early on, and did the order of the barristers thing, the moot court thing. Always liked talking in court. And when I got out of school, I worked for what was in the South, a big size firm, but many people were losing their jobs, so the conditions were tough to work in. And so early on, I got picked up by a plaintiff's lawyer for the Deepwater Horizon Transocean explosion in Louisiana. And that was the first kind of experience where I represented families and people who were hurt. I didn't do that as a primary lawyer. I was working under a very well-established lawyer who worked out of Houston, but um, that experience kind of led me into learning to be a little more entrepreneurial. We kind of had to be during the recession. A lot of the big law jobs were getting scrunched, and we had to take time away from the big law jobs and things like that due to the economy. And I ended up just still working for that plaintiff's lawyer, and he sent me a lot of work. He gave me an option kind of at the end of the Deepwater cases. Hey, some of these big firms really would like to maybe have you. You can pick that, or you can go. I could send you work, and you can continue working on your own. And I picked working on my own, and so I did that. I moved up to Seattle, where I'm from, a couple of years after that. And I started my own practice down in Fisherman's Terminal in Seattle. That's an area where a lot of fishing boats and industrial vessels get worked on, get stored for the winter, things like that. And I picked up cases from companies, actually. So I would do commercial cases. And I got into oil and gas work. And I started doing London arbitration type work, bigger cases where you'd have a big tanker of fuel get contaminated, or there'd be some contract dispute, and companies started slowly hiring me. And then I got an offer to go be in-house counsel, general counsel for one of the biggest maritime organizations in the country, for their oil and gas division. Me being newly married and having a little boy, on the way, I said, yeah, let me take it. And I thought that was exactly what I wanted to do. After doing that for a number of years, I decided I didn't want to do that anymore, because my heart was always in trial lawyering. That's why I went to law school. And so picked up a Jerry Spence book, and I blame him for starting all this. And I became enchanted with the words on the page from Jerry Spence. And I started looking him up, and somebody introduced me to other people, like a guy named Rick Friedman. And I became enchanted with what he was writing on the page. And I came to my wife and I said, can I please stop my job, and can I go do this? And long story short, was she said, yeah, you seem miserable. I'd really like that. So she took a chance with me, and I started my own practice. And I went from being in a really big building downtown in Seattle, and a big fancy office and a nice title and a big spending account. And I moved into a small building that my mom owned in a suburb, into her basement. And yeah, I started practicing in my mom's basement from working in the big place downtown. And I took it one case at a time. And a lot of times I'd work for free for some of the biggest names in plaintiff's law and develop relationships, but I got a big education. And over time, started getting my own cases and winning them. And that led to the next case, to the next case. And here we are now. And the journey's been awesome. And I get to represent people who really need the help against really big organizations. And I get to work with great people. I just finished this trial we'll talk about in a minute with Rob Fulton. It was an absolute honor, pleasure to work with him. He's a guy you want to be in a foxhole with, and I get to meet great people like that, work with people like that. I get to work with great clients. I get to help people, and I get to do something that's really meaningful to me. And I get up in the morning, I'm excited to do my job. And so that's the short trip. And now I have an office in the hometown where I grew up in downtown Edmonds, which is about a 25-minute drive, depending on traffic, from Seattle. And I walk to work about 10 minutes every day. So there it is.
Thanks so much, Joe, for that. That helps us to get a little bit of context. I happen to know there's some similarities in your co-counsel Rob Fulton's background. Rob, can you tell the audience a bit about your background? Maybe starting with your background working, playing Division I sports in college. And you start there and kind of bring us through to your practice now, and what you focus on, and your general approach here.
Sure. Yeah. So, yeah, I had an opportunity to play college football at Montana State, and the college experience is something where, and specifically a team experience, you take a lot of things away. And so that was the early development of some of the things that I've always held on to, and wanted to emulate as I moved into my career or whatever I wanted to do. And I knew I wanted to go to law school. So, the things that I remember definitely, and I'll apply them to later on today as we talk about this case. But, the things that just ring in my head that I can't ever get out or what my coaches always talk about. And, the first thing is, it's team and understanding, working together. And as Joe mentioned, being in a foxhole together. I don't think there's a closer thing you can do, other than being in combat, or than when you experience pain and joy together with one another, that people from all different backgrounds coming together for a single goal. And you develop that over time. It's not a one day thing, but once you get it, you don't want to lose it. And something I'll never forget, those experiences. But but one of the key things that, as I take away from school and working on a team is listening to others and trying to understand other people that aren't like you. And it's important. And it's important, definitely in plaintiff's work, where you're dealing with folks who, you may not have been in their shoes, but there's something about them, something about what they've gone through that you can connect with. And finding that and ability to do that is so important. And so, when I got done with law school, big dreams of working for a big firm, all these things, initially, are in your head. And so I started out on the defense side. Um, and actually, that's when I met you, Zach, obviously, in the asbestos litigation. Over time, the best way to explain it is that, my life was being drawn down to nothing. And the things that I wanted to do for people, I had no opportunity to do. And so, as much as I learned from some very skilled lawyers, things that I'll always take with me, in my heart, what I wanted to do was to help people and not to help an entity, a thing that you can't put your hands around. But you can look at it in dollars and cents and say, we made a profit this year. Well, that meant nothing to me. And so, long and short, I ended up leaving, going out on my own, and I had worked in employment areas, and I thought that would be an enjoyable thing to do, to help folks who are basically at one of the worst places in their lives, when they lose what they think is their identity, either by loss based upon some type of, whether it be race, age, some type of discrimination. So that's where my sole practice, I worked. I had a partner for a while, but then I worked on my own at Fulton Law PLLC. Continued to do employment work, but at the same time, I had an opportunity to take a few cases to trial, and that's really where I wanted to be. And the thing with most employment cases, though, 99% of those cases you settle, so you don't get a lot of opportunity to try cases. But eventually, yeah, as time comes around, I end up working with you, Zach, again, and so now I'm of counsel with Herschensohn Law, working in the litigation department that we call our litigation group, preparing and looking at trials that we're going to take to trial, and managing those throughout the process. And that leads us up to where we are today. One of our cases, Aaron Wood, and have an opportunity to work with Joe Pipinich, and it's been just the start of what we want to do for folks that are injured and need to have some type of value put back onto what was taken from them. And so that's kind of a little bit in a nutshell.
Thanks very much, Rob. So Joe, You got involved in this case, I think it was in 2000, 2023. I'm not sure exactly of the date, but can you give the audience just your top line impressions initially of the case when you first got involved?
Sure. So I think, Zach, you brought me into the case about, give or take, about 5 months before the actual trial date happened. 6 months, maybe, somewhere in that ballpark. And when we came into the case and teamed up together, my initial thoughts factually were, our client, Aaron, early 40s, born and raised in Snohomish County, which is the county just north of Seattle, King County. And she grew up in a rural environment, grew up with animals, and she had a love for horses since she was a little girl. And she had built her own business as what's called a horse farrier. That's somebody who takes care of the horse's hooves, their feet. And if you don't take care of the horse's hooves, the horse can get really seriously hurt and affect their health. And not only did she do this for a living, she built a whole community, and she was integral to this. She donated her time to the elderly, veterans, nonprofits, children. This is somebody who gave and gave and gave. And what made her unique was that not only was she a giver and a pillar in her community, she didn't have much money. She decided she wasn't going to charge big dollars. She wasn't chasing money in her life. It was about her community and taking care of others and animals. And part of that was that she volunteered at, there was a landslide here in Washington State. It was one of the biggest landslides, might be the biggest, most deadly in the country in 2014. So about 6 years before the crash. And I don't want to get into all the details because it'll gruesome, but she really saw some horrible things, and she gave herself to rescue people and animals, and the things she saw and experienced were pretty traumatic. And so she had mental health issues from that. She had PTSD, depression, anxiety. This got in the way of her life, and she'd have to manage it. And she fought every day. And she was also doing a very physical job, so she had all these joint pains because she'd been doing this job for a long time. And she had to miss some days of work. So these were all things before the crash that were already happening. And it was also right at the time of COVID when the crash happened. So this was really even tougher on her financially. And that was all over her medical records. It was very well documented. And so even though this is somebody who's strong and a pillar of the community, you look at things like medical records, you see a lot of struggle. And typically on a case like that, I imagine the defense looked at this and they said, oh, well, this person's got all these problems, probably going to be the same after. And so that's what we were faced with. And one last point is the personality, Erin. She's somebody, I think a witness said it best in the case. The defense was trying to make an issue of Erin being maybe difficult or not likable, which wasn't the truth. But the witness said, well, Erin doesn't suffer fools. And that's the person we had who, for however you want to phrase it, didn't fit in a neat little box of perfection and innocence that maybe some people want to have their clients fit into. But it's who we had, and it was our client. So that was the situation going into this. She got hit behind at 50 miles an hour, give or take. Hit her trailer hitch, or that she took her horses around in it. All that energy went right into her trailer hitch. And after the crash, she got treated for low back injuries, including concussion. And the low back injury just never subsided. She's had to get multiple injections, and she's just managing pain. There wasn't anything on the MRI that said, oh, this is for sure it. She didn't get any surgeries, but it changed her whole life. And the defense was hanging their hat on her mental health issues, the fact that she had all these joint pains beforehand, and that she was having financial struggles, and essentially was saying, this is somebody who's basically kind of crazy and faking the injury and not worth the money, not worth being valued. So that was in a nutshell. That's what we're facing.
And so you mentioned horse farrier, right? You alluded to the background that Aaron had in terms of the Oso mudslide.
Mhm.
As I was writing the byline for the little summary that I'm going to publish at some point here, it just struck me that those are sort of interesting. This is an interesting case, just kind of, top level, just the fact that she's a farrier, which is it's a very unique job, right? And there were a lot of things that at least the lay witnesses, but also Aaron, were in a position to testify about. Can you maybe expand on that and talk a little bit about how the fact that you had sort of this interesting subject matter and storyline that you were able to tell, how that influenced your presentation of the evidence to the jury, if at all?
Yeah, no problem. So ferrying is something that Erin did 5-6 days a week, all the time. Before the crash, she had a few brief periods where she wasn't doing it, and after the crash, she'd been reduced to about 2 days a week, part-time. And ferrying is where you're bending over and you're managing a horse, but the full story, if you looked past the fact that she could actually work a couple days a week, was that there was a much deeper story there. She was putting herself through every little bit she could to keep her connection to the horse community. And once you understood her exact injury, which we can get into a little more detail later, and you got past that surface level that, oh, hey, there's a human being that says they're really hurt, but I still know they ferry horses. And in fact, we had a social media post the defense had that they were just going to flash up there and say, if she's really hurt, how is she able to do this? And we had those photographs and we knew they were coming into evidence. And so that was something we were facing going into it. So we knew, all of us together, Zach, you included, I know you're emceeing this thing, but you were very involved in discussing developing this story. And Rob, obviously, everybody was integral. It took a whole team effort. We really took a blowtorch to the story to find out what the truth was. But at the end of the day, we knew we couldn't let the defense have their story. We had to tell the story and take it from them. And that meant getting into the truth, even if somebody could interpret something where, you might be worried that this is a bad fact. Well, there are no bad facts. They're just facts. And so that's what we did to tell this story. I'll let you get to the next question. I don't want to run on, but that's kind of the setup, if that answers your question of what we're looking at.
I think it does. One thing that I'd like to try and draw out of you, just because the audience for this is presumptively other attorneys who might want to have some insight on how this might be replicated, because it's an absolutely outstanding result. I kind of know the answer to this, but since they don't, Joe, can you just talk a little bit about how it is that when you first get involved in the case, what is it that you do? And I'm thinking particularly about your interactions with the client, with the plaintiff. You just to try to talk a little bit about what your process is in terms of kind of getting from step one to the next phase in terms of your client relationship. If you could just sort of briefly describe that for the audience.
Yeah, you bet. So I told you earlier that I was enchanted with Jerry Spence, his pages and what he wrote. Same thing with Rick Friedman, and there's countless other people to learn from. We'd spend a lot of time doing that if we went through every name. But what I was taught was to build a relationship with your client. And you can't really know somebody you can't tell somebody's story until you understand them to some degree. And that takes a relationship. Otherwise, we can talk more about this later. Otherwise, you're just going off of themes and caricatures. You know, you're going off of a figmented character you think they might fit into in a box. And the more information you get and the more trust you get, and the more somebody opens up, they get away from those boxes and figures, or these characters that are kind of archetypes, and you get away from them and you get into who the person really is. And so step one is developing a relationship with your client. And that means relationships are two-way streets, right? It means they got to get to know you a little too, a lot. And that's how trust is built. You give trust over, and typically trust is given back to you. And that's something I learned in a lot of work with people who really taught me how to find a story. I learned that from other people who taught it before me and probably had it taught to them in some way. And I like people, I like their stories, I care. So it's a job I like to do, but it takes a lot of energy. And so that's step one, is to build that relationship with your client. Then step two is to do the nitty gritty work that may or may not be somebody's bailiwick, which is, hey, look at all their medical records. Like, look at the things on paper the defense is going to try to make this story, so you can understand how the real story fits into papers and photographs. And those are the two most critical steps, and I think they're fundamental.
So it sounds to me like your first step is really to spend a lot of time with the client, time on the phone, getting to know the client, and that leads to the capability, or at least the foundation for the capability of extracting a story or developing a story for the trial. Is that a fair?
Yes.
How it works?
Yeah, that's a good summation of it. Yeah.
Can you explain, and you know, because I want to respect the time limits that we have, but if you could just summarize what story emerged for you after that process, and then how the actual underlying medical situation with Aaron kind of led to the structure of what you were going to present in terms of the actual underlying injuries, as far as focus and direction, as far as the presentation of the evidence at trial.
Yeah, you bet. So what I've learned is the process I go through, which is, it is a process, follow the process, it's a 3-step that I go through. And I want to talk about each one of these steps real quickly. So step one is understanding what is the injury and how has it physically affected somebody. Like, you know, how does it mechanically affect them? What's going on medically? So you have to know the science and the medicine of what you're understanding or not understanding, and figure out what's mechanically wrong with the person. That's step one. And that's the easiest level to get through, because you can kind of get that by reading paperwork. And you can talk to doctors about getting to know somebody. And if we were to go to court and simply tell a story about, you know, I'll use any name, whether it's Aaron or Steve, Joe, Sally, whatever. If it's a case about Sally's back, well, Sally's back doesn't get up in the morning. Sally's back doesn't have dreams and hopes. Sally's back doesn't have a life. Sally's back is merely an apparatus on Sally. And so that's level one. And if you all you do is say, hey, this is mechanically what's wrong with them, you're not telling somebody's story. Level two is, okay, what is the limitations from Sally's back? I'm just using any old name I'm making up. Sally's back affect the things they like to do. So maybe Sally's a skier. Okay, great. Maybe Sally's a walker. Maybe Sally's a new mother, wants to pick up her baby. Maybe Sally's a grandmother, wants to pick up her grandchild. You get the idea. How does Sally's back affect, and the condition it's in, affect Sally's life? What are the experiences she's missing out on? Okay, that's level 2. And in my experience, a lot of people get there. Most people get there. It's level 3 where I think the difference is made. And I want to talk about level 3 in a second. Well, let me first talk about why level 2 isn't enough. Because level 2 might be something somebody relates to or not. Maybe somebody doesn't give a whiff about skiing. Maybe they go, hey, I've never skied in my life. That's a luxury. I have a bad back and I just get to the bus every day. Or maybe somebody can't relate to, pick up the child. Maybe they don't have kids. They don't really value that. Well, you get somebody else to do that or something. I don't know. You can make up a million reasons why people may or may not identify with that story. Or those just basic facts. And some people can take those and grab those and relate them into their life in a more meaningful way on their own, and some people can't. And that's why level 3 is so important. And level 3 is what's universal about why that activity is important to the person. What is it about that activity that gives that person meaning, hope, drive? And the answer to that isn't, oh, I like skiing. The answer to that is usually much, much deeper, and it may go back to their childhood. And once we get into the reason why, then we're getting into the feelings. Deeper things. Shame, isolation, lack of independence. I can go on and on about these feelings. Feelings can be universal. And the reason why can be highly related. And to learn somebody's story, you can't just learn the mechanical, and you can't just learn what it's limited them from doing. We have to understand why it's important to them. And to do that, you have to understand the person. And that's the process where people can really look at your client, and we look at each other. We all built this way. We can look at each other and we go, wait, well, they're like me. We're human. We love each other. Yeah, but that's what's important. Yeah, you work to take care of your family. You work for a reason. You don't work for just money. And so once we get there, that's now we're somewhere. Now we're somewhere beyond money. We're somewhere beyond the job. And now we're being human. And that's the process. And sometimes it's grueling, to get there, because for somebody to tell you what their hopes and dreams are, and to really tell you why it's important to them, they might not even know. They might not even thought about it yet. And so you might even have to just get there to begin with. And that doesn't come by just sending them things to write down on paper, or a single phone call, or a phone call with somebody who works in your office. It doesn't come from that. It comes from them being vulnerable. And there's no way to get there until you build that relationship of trust. So I've given a lot of thought. It's a process that I've just put a lot of thought into, that 3-step process. So anyway, hope I didn't burn up too much of your time, but I wanted to share that.
No, one of the things I thought was very interesting in terms of the dynamic that manifests at a trial, and the way that I think the story of the loss of hope, perhaps, the shame, isolation, lack of independence, those things I think really came out in the trial, and I know they were part and parcel of the trial prep that you did. But I felt as if there was a part of this case that manifest as in some ways as a reaction, or at least it in a dance with the actual defense that Doug Foley presented. Maybe you could just give the audience a little bit of a taste of what their defense was with a little more detail. They chose to hire 4 experts: Elizabeth Ziegler, Hal Rappaport, Dean Shibata, and James Harris. Maybe you could take that and run with it, because I'm sure some people watching will have had experiences with those experts and have and benefit from your impressions about how that defense, in fact, actually became part of what I think the case was about in terms of themes and so forth.
Sure. Well, first I'd say that, well, Zach, I know you had 3 of those 4 were on video. And so if any of your listeners, I'm sure, wanted to see those crosses of the experts of the defense, they could probably reach out to your office and get them to talk to you about that. This is a starter. But those, I mean, I guess the blunt way to put it is they made stuff up. I mean, no other way to put it. They made stuff up. They made up medical records that didn't exist. They said treating doctors, not just they, but the neuropsychologist who never did any psychological testing said the treating doctors got it wrong when they diagnosed the patient, Aaron, with a concussion right after the crash, wrote it all over the diagnosis in the medical report. Saying that somebody with a neuropsychology degree saying an MD got it wrong who was there in person. I mean, you can't make this stuff up. You had doctors who would come in on the other side, an orthopedic surgeon who came in and said, "Oh yeah, no, there's this imaging that shows her low back was hurt before the crash, and it's the months before, and it's all there." And then not only was it not there, another member of your team, Zach, who was assisting me with that, pulled up a list of all the imaging like that, which was huge. And we actually showed it to him and said, "Where's this imaging you're referring to?" And whoops, maybe he was thinking another case. I don't know. And then we made him fill out a form, or I filled it out for him. There was a simple questionnaire. It said low back pain, and I put all the years before, or we put all the years before the crash, one by one by one by one, until we got to the crash, right? And it was low back pain, yes or no. It was real simple. And that expert had to go, okay, yeah, no, and go no. And he fought every step of the way. And then we just, we showed that he was full of baloney. And he finally agreed in his own words, yeah, no, 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 no. And then finally got to the crash, low back pain after that, yes. And we printed out a big cardboard exhibit. And that was the timeline that mattered. And their own expert endorsed it because he had to admit it because he got caught lying. Or maybe it wasn't lying, maybe just confused with the case he had going the next week because he was getting paid so much money on him. I don't know. But, they took such an extreme position where it was it was an admit nothing defense, even the things that were so obvious. And that in my opinion, that just put gasoline on the fire of destroying their credibility. And for your listeners who want to know some of the intricacies of that, just read Rick Friedman's Polarizing the Case. If you haven't read it, read it. It's the manifesto on how to create a gulf between the plaintiff and the defense's case to create tension in the courtroom. So if you haven't read it and you're interested in this, read it. You'll learn a heck of a lot more from that book than you will from me right now. But that happened in this case. It was very polarizing, extreme, and we stuck to the facts. We didn't tell the jury one time what to think. We just showed them facts. We did the work to lay the facts out, so let the facts tell the story. And the other side just kept telling them what to think. And the facts didn't line up with their conclusions. So is that That's kind of the gist of it. Is there anything else you wanted to ask me about?
You hit it. When I spoke with Rob earlier, he mentioned that the energy in the courtroom really changed when when she testified.
Mm.
And
Yeah.
I think that that obviously is a very important witness. She was certainly somebody who you could have seen it go either way. And I know you spent a lot of time preparing her to testify, um, or working with her. Is there any insights that you can give the audience about that process, how you prepare a plaintiff, or how you prepare a witness, but specifically a plaintiff, to be able to present their side of things without compromising their capabilities? Because I feel like that could have gone either way in that case. But I think actually it came through well. Can you explain how that process was in this particular case, maybe just generally?
Yeah. So our number one goal always is to tell the truth, and good or bad, just the person who they are. But it's our job to not make the jury put it all together. That's our job, is to put those facts together so they can make decisions on the facts. So we have to do the heavy lifting of putting the facts in order, picking the important facts, the ones that don't waste the jury's time. It's like editing a movie, right? Do we need that scene? Do we need that scene? But hiding nothing, right? So it's a resemblance of the truth. And one thing that made this case difficult and easy was that Aaron is such a strong personality. Such a strong personality. That if it wasn't perfectly dead on to how she wanted it, and luckily for us, this part was easy. She wanted it to be the truth, whether it was a good or bad fact. And that made it easy because that circumvented our discussion of how to get there. But she's such a strong personality, it was one of those things that we had to really do honor to how she wanted to be presented, which we should do with all of our clients, but she was very particular about it. And so that required us to work together a lot to make sure that we were coming together as a partnership about what was going to do her the most honor, but be the most raw and honest at the same time. And I think the turning point was getting to that place where it wasn't about worrying about what the jury was going to do or trying to influence what they were going to think at all. It was about just her finding that voice inside of her, where she looked back on this trial and no matter what, no matter how these people judged her, that she stood on her own 2 feet and told her story with integrity and respect, in a way she could look back on this and feel proud that she fought for herself for the rest of her life. And that's what we could control. We can't control the verdict. And so getting to that place where our goal was about making this more meaningful than just what's the jury going to do. Make this about her and her growth and her statement as a human being. No matter how many experts on their side hired to turn her into a liar or try to, manipulate the situation. And when we were getting done with that, we all looked at each other and we felt awesome because we felt there was integrity to this. And it was her journey. She owned that. We helped her get there, but that was her accomplishment. And so she was very empowered. And this trial would not have gone the way it did had she not dug deep and taken the chance just to tell things and be vulnerable and be willing to be judged by those 12 jurors. And she did. She killed it.
I know that just simply from a temporality standpoint, that you had that you had Aaron's testimony preceded by a lay witness, and then I believe followed by a lay witness, or something to that effect, and that there were a number of lay witnesses in the trial. Can you speak to both of those decisions? One, to the timing of the witnesses in terms of their relationship to when Aaron testified, and then also just the role that those type of witnesses played in the case.
I'm going to let Rob handle most of this. I'm going to say a couple things because Rob did the majority of the lay witnesses. And what he did was just raw, honest, and so well done. I'm going to let him describe some of that process. The short version is lay witnesses are easier to understand. They're not being paid. And the jury, all of us can kind of, I think, have that inner sense of, is somebody trying to make us think something, or they have an agenda? And I think that when people talk about regular things and regular folks, we have a more openness to listening. But still, we all still have the same meter of the BS meter. So relay witnesses actually tell the story that you don't get in the medical side. Remember that mechanical thing? The lay witnesses don't get in the mechanical thing. Remember the 3 steps we went through? They don't get in the mechanical thing. Yeah, they'll talk about step 2 a lot. What I see, what I don't. They verify that, like legitimize that. And then level 3, if they know the witness well and they can speak to the culture, and I'm going to stop there, they can provide an avenue or a lens into that level 3 that we talked about. I don't know. What do you think, Rob? You did the magic on most of all of them. So this is your zone.
Yeah, I think what when Joe went through and he talks about getting to those the 3rd level, and the beauty of our case was all the witnesses had some deep involvement with Aaron, either a friendship or a professional level, but it was outside of her CrossFit community. The bulk of the witnesses were talking about her the horse community and what that means, and all the themes that we were trying to bring out in this case. You know, and getting to that level where people could understand what it would be to lose something that provides them with a sense of identity, a connected, being bound to something. Those are universal feelings. And whether you are a horse person or not, you understand what it means to be connected to something that if it's taken away from you, what am I going to do? And so, the thought process obviously was to buttress Aaron's testimony, but really as I would say, bring it to life and add color to it. And as Joe was talking about preparing witnesses to tell the truth, part of that process is helping them understand that we want to hear it from their words, from what they see, from what they've experienced. And don't provide them with words to give, but to let them understand, we want to know what you actually saw and felt when you interacted with Aaron. And so there were just some vivid pictures that were painted, I think, for the jury through these lay witnesses as they talked about having this bond with a horse. And how it wasn't a job. It wasn't something that I just liked to do, but it was everything for Aaron. And that connection and loss. And one of the, I think, key points, or one of the huge facts in this case was, the loss of one of her horses, Ben. it was just, it was traumatic for her, and she referenced him as being her soulmate, right? And so for the whole trial, we're not even talking about horses in terms of, you know, an animal, but they're people. And so Aaron was this person, as you know, we paint this, you know, doesn't suffer fools, but she would give anything, anything to be with her horses, or to be with other horses, or to help horses. And so, you know, the goal was to make sure that we helped the jury to see that even though she could work maybe 2 days of the week, there were so many things that she wanted to do that she couldn't do, but she would still get up and try to do it, and that would put her down for maybe 3 or 4 days straight. But her love and her bond for the animals was what these lay witnesses brought out and shared stories, and it was so important for them to provide that, I think, to the jury. And one point on that is, you know, after we polled the jury at the end, and some of the key things that they said, number one was that they believed Aaron, and part of that is everyone, all the lay witnesses corroborated and expanded on Aaron's story. It was real. And so I think that's why they believed it. They understood it. And then secondly, that universal loss of something that means so much to you, even if you have no understanding of what it means to have a horse or an animal. But the jurors said, you know, I play an instrument. And to think about losing the ability to do that, I don't know what I'd do. And that's when you could look at the witness and she's real. Every time they talked about horses, she lit up. And I knew she wasn't lying. I knew she wasn't lying. That's what the witness or the juror said. And so, you know, that's the role of these lay witnesses to fill in those gaps and to bring it to life, and to support the foundation, whether it be you know, these themes that we had going through. The loss of community was huge, and I think that was you know, one of the pivotal points in the trial, that when they saw that, they were there. And then also to piggyback on what Joe said about, you know, Erin and her, you know, she doesn't suffer fools. And you know, and one of the points in the trial, they tried to bring the surprise witness to, you know, to destroy our case. And in the end, that's when I knew the jury was with us, because when the witness was done, said what she was going to say, and there was some stuff that was brought out that, you know, wasn't becoming of Erin. But it's when the juror asked the questions, when jurors got a chance to ask questions afterwards, and the question was, you know, well, didn't that make you frustrated? And so they were rehabilitated and helping Erin to make us understand what was going on in the situation. Yeah, she used some choice words, but there was a reason, because she was frustrated, because she loves animals and she would never allow any animal to be harmed. And so, you know, that's the beauty of it. And I don't know if that answers your question. If there's more you want, Zach, let me know.
So yeah, I think it's very interesting, because I think when Joe talked about the 3 different stages of communicating, you know, what's mechanically wrong with the person really can't be avoided. That part, step 1, you know, what's the explicit limitation, and the effect on what they do. That's kind of where you get Becker. So you got to have a medical provider that's, you know, kind of give you the step 1, and maybe just summarizing the actual treatment and the diagnoses and so forth. What are the limitations? That's Becker. And then what is universal about the loss? And then, you know, you talk about the loss of drive, the loss of independence, isolation, shame, etc. Fair to say you tell that through story, and the story is then, it seems to me, authenticated by, first place, the plaintiff, but then perhaps importantly by these lay witnesses who say this is the truth, right? They authenticate the story. Do you think that's a fair summary of the sort of the process and maybe how things get presented at trial? go ahead, Joe. If you think that's
Yeah.
that summarizes
Yeah, I think that's a good summary. And I would even add something to this that's I'm sure we'll get to, but it's probably the most critical part of the whole trial. And that is, what's the role of the jury? Right? The jury. We had a great jury. Start there. We had a jury that was looking for the truth, very hard, tough questions throughout the case. And, you know, we laid out the story in such a way where Aaron has a beginning and a middle and end, like we all do, right? Like every story has. And we brought the jury into her story. And by telling it, and I like to think, it's like a movie, right? I mean, I'm kind of a softie, so I have a lot of movies where I get a little tearful. But when somebody makes up a movie and they tell a story and we know it's not real, I mean, for the most part, there's actors in it, there's music and all, and we know it's a show, but we can still get moved emotionally watching a movie. And why is that? Well, relate that back to the jury, is that the jury isn't just watching the movie. At some point, it becomes apparent that they have a role in the movie, right? And they get to this story of our client, and they say, here's been the first half of her book. She was 42 years old at that point. Judicially, what do we say? There was 43 more years technically the rest of her life. And we got to the jury instructions. And we got there and we said, she were to write her book. We know what it looks like. And then what's her future look like? Now, here we are, this page in her story today. And she's going to look back on this page because we're all here together. We're in her story now. And I think that's the moment where people start realizing on that jury, I hope they do it. And I think they did. They validated it with their verdict. That they have a role in her story. And they have responsibility. And at the end of our trial, we transferred that responsibility from our job and we handed our client to them. And if we've done our job right, they know they're there for a job, for a reason, to judge, to decide what's right and what's fair, and to act on that. And only them. And Erin will look back the rest of her life, and her life will be, stamped and marked, whatever you want to call it, by what they do. And that is the ultimate place where we end up with this. And the jury was amazing. They wanted to do a good job. They did a great job. They were in it, and they did unquestionably the right thing in our case. But they did that because they decided that was the truth and the right reason, not us. So that was kind of the way it ended. And like I said, we even got a chance to interact with one of the jurors and hear from them. So that was really helpful.
Rob, I'm going to pose the same question to both of you, but I'm going to ask Rob first, and then I'll ask the same question of Joe. What did you learn from this particular trial experience that you feel will help you in future trials?
Well, I think the first thing is, Joe already hit on it. It's building that relationship, and I think at times we can we want to short circuit the process. We want to cut corners, but you just can't. To develop and when Joe said, the transfer the responsibility over to the jury, you can say that, but when Joe said that, he meant it. And they could see that he meant it, because at that point, everything that you've been working for and and preparing for, you you had to let it go. And as Joe said in his closing, I've been holding Aaron. And if that's real, jury can see that. If that's not real, it's just a phrase. It means nothing. And so when he said that, the jurors looked at him, they knew Aaron's now in their hands. And that was real. And that's one of the biggest things I take away from this case is, again, is that, you can't short circuit the time you spend with, whether it be a lay witness or your client, and trying to understand their connection, not only to the injury but to the person. And that's just invaluable. You can't do it. It's earned. It's earned, and you earn that trust with people by spending time with them. So that's what I would say.
And Joe, same question to you. What did you learn from this particular trial experience that you feel will help in future trials?
Too many things for one show, but for me personally, for where I'm at in this journey of doing this thing that we get to do, it's a privilege. I would say the number one thing that I get to walk away with is the team of people I got to do this with. I'd never tried a case with anybody on this legal team before. And that was going through that, having Rob right next to me, doing the work, having somebody named Sarah Leonetti, who's going to be doing her federal clerkship, probably her third one. She's going to go back do that. She was stepping in the game, was our backstop, was a brief writing machine, and was every inch of the fight. Your staff, Zach, was phenomenal. Zach, you were great with the support. Really, it was a perfect environment, and everybody was supportive. Everybody was on the team, and they were there for Aaron. There wasn't any. That's why we were there, was for Aaron, to do the right thing. And when you work in a team of people like that, it's special. It's special because everybody's working for each other. And I would say in this particular case where I've been at, I've had really great experiences in the past. I've worked with great people, and being together with this team really was awesome. So what I learned is, we need each other to help each other. And I kind of running out of words. I'm having mostly feelings. It doesn't help on a podcast, but but I can't wait to get back in the foxhole again. And I'm with people who are proven fighters. And I think that's probably the biggest takeaway in a world, a sea of takeaways that were from this case. There's just not enough time to get into. So that was cool.
Yeah, actually, I think this is a good place to break. Krista, I know you've got to get something in a little while. I would just say I'm willing to extend an invitation to do a part 2 of this if you guys were enjoying it. I know I would get a little bit more out of it. We don't have to go over a full hour, but I know we have to break now. Otherwise, we could just sort of end there, and I can kind of do maybe I just do a 2-minute summary, Krista, and then you'll have a conclusion if we need to plug that in, if these two gentlemen are not able to do that. So you want me to go ahead and do that? Just do a conclusion, and then you can edit that in as a conclusion if we don't end up doing another session of this.
Yeah, for sure. If you want to just add it in here at the end,
Oh,
and
so
then we'll talk about.
Let's do that right now.
Okay, great.
Yeah, so we were recently on a conference call, Joe and myself, with a neurologist. And the neurologist said something that I thought was really instructive. He wasn't talking about trial work, obviously, he's a neurologist, but he said the brain is a storyteller, not a replicator of reality. And I just thought, that just rang in my ears, rang in my head. And I think it's really instructive, that quote. Obviously, I talk to experts all the time. They say things, and I don't remember what they say most of the time, but this really resonated with me. And I think that my takeaway from just being sort of fly on the wall and watching you guys do this was to see how the story hung together, right? How you guys brought in witnesses that gave the imprimatur of authenticity to Erin's story, which was true, which was a true story. And she really was jacked up and was in serious chronic pain, which was, only capable of being communicated because it was true. Right. So I think that was really important. And the story that was told was communicated appropriately because it kept time with that principle that the story was being told. Joe and Rob were the storytellers, and it resonated with the jury, and the jury was able to complete the loop in the way that Joe described. So I thought that was really what I came away with from the trial, and just very impressed. I want to thank you guys both for everything you did for Erin, and I think it was really a wonderful presentation of that experience for the purposes of our audience. So thank you both for joining us, sharing what you could about that experience, and I'd like to invite you to come back and maybe talk about your future experiences. I'm sure we're going to have a lot of them that we can describe in the future. So thanks so much for joining us, Joe. And thank you so much, Rob, for coming and talking about this.
You're welcome. Thank you for having us.
Exactly.